I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are dropping another compilation video, but today we're going to do something different with this compilation video. We're going to share specific types of sovereign citizen proceedings on today. And the type we're going to be dealing with today are those sovereign citizens that we shared in the past that didn't want to take responsibility for their children. They used the sovereign citizen script in some type of way, shape, or form to try to get out of child support. Before I give you the rundown on the judges' courtrooms that we're going to be in on today, just know that we will have chapters as always in these videos. So if you've seen something before, you can just jump to the next video. Also, there will be no commentary at the end of this video. So with that being said, thank you guys as always for your support, your love, your likes, your shares, comments. It is all appreciated. With that being said, guys, let's go ahead and let you guys know what judges' courtrooms we're going to be in. First, we are going to be in the courtroom of Judge Colin Hunter out of the state of Michigan. Second, we will be in the courtroom of Judge Claire Jason out of the state of Georgia. And last but not least, we will be in the courtroom of Judge Brock Swartzle out of the state of Michigan. Now, these were some, some classic moments, but also at times, watching this, some very unfortunate moments, especially when it comes to dealing with kids. But I've talked enough. Let me get ready to get out of the way, guys. Let's go ahead and jump into these proceedings.
Thompson. That is the person that I was given to use in this life. And that proper style is upper lower case in accordance with SPR 89363, which is a court order to the full faith and credit.
I'm going to speak one more time, and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple identifying questions because I've just called the case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes. I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure. Yep. Yes.
Are you David
I feel
Glenn
really
Thompson?
coerced right now. Thank you. I appreciate that.
Are you David Glenn Thompson?
I believe I just answered that with a yes, and I feel really coerced right now.
Mr. Thompson, I'm not going to allow ridiculousness to control the day in this court proceeding. I don't view this office as needing to allow that, and the law doesn't view this office as needing to allow it. I have a simple and straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this. You can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear, and it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause why you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the friend of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the friend of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up. I'd prefer it go back to them.
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, the law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based on my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter is, or should be aware of the fact that when posted, it could be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears, if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court. But hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold equivalent, registered mail to Clerk Divider, I think it is, and why that wasn't credited to the account, since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult, but it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article 3 court, or things referencing a surety contract or other words that, although they seem quasi-legal, don't bear any particular relation to this case. And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears-only matter. And I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes, and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard, are present in this case, and that is, I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion to bar any further oral argument by Mr. Thompson. Instead, I'm going to follow the suggestion of the friend of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Boyd, on this case?
No, sir.
All right, thank you. The court is at recess on this matter then.
Good morning to both of you. This case has been going on since May of last year. In this case, Ms. Simmons has an order for $437 a month as the primary payment for child support, and she has a payment of $87 a month as a repay. For my math, my mind is not that efficient to figure out the amount, so let me just put what he's supposed to be paying. 437 plus 87, I think is what I said. All right, the child support payment is supposed to be $524 a month. Looking at my notes over time, both parties were present in June of last year, and then in August of last year. I've given multiple resets. And then he was here October. And then I dismissed the case because you were consistent in October of 2023. Then in August of 2024, she refiled because you stopped making payments. And then I set a Zoom date. I actually issued a warrant for your arrest. But we reset the case because you came in person and indicated that you did not get the hearing notice. I don't usually give second opportunities when I've worked with you for a whole year to get you back on track, and then you just fall off. Generally, that's a problem because you know you're under an order to pay child support, and I've already given you the opportunity of what I call redeeming yourself. Looking at the order, you have mom has custody of Abraham, Asher, and Naomi, 3 children. That's not a lot of child support for 3 children anyway, but all right. And so looking at your child support order, it looks like mom was receiving unemployment payments for April. And then when we came to court last month, DCSS said that they saw that you may have had a job and they were trying to see if they could get the child support taken directly out of your paycheck. I reset the case to give you a chance that if there's an income deduction order, I would recall the warrant and let the income deduction order continue to proceed, but there's nothing to date. So last payment mom received was April, I believe. And so that's May, June, July, August, September, October, November, 7 months, 3 kids, no support at all. As what I'm showing. Okay, yes, you can raise your hand. Yes, Ms. Simmons.
I submitted evidence as well. It was something that Mr. Simmons had filed with Superior Court, I believe. So I think they may have it. They said they were going to upload it for you to be able to see it.
Okay, give me one moment.
Mhm.
Mr. Keys, Joshua, do you see anything from her that you could forward to me?
Yeah, let me give me 1 second. Hold on. I'll look.
Okay, give me one moment, please. And you sent it to the magistrate court clerks, Miss Simmons? Okay, give me
Yeah,
one moment.
they made a copy of it. Yeah, I took it into the office.
Okay. All right, while I'm waiting on the information from Miss Simmons, Miss Serena Camarillo, is there any update on the information that was sent in on the ID?
Yeah, I'm not sure when the last meeting with the court was, but I can say that on August 22nd, we received a response from an employer via fax stating that he was no longer employed at the location where we had sent the income withholding order to. They said he
All
was
right.
no longer employed there as of August 22nd, 2024.
All right, Mr. Simmons, while I'm waiting for Miss Simmons' information to be sent, mind you, I've already issued the warrant for your arrest, but you can go ahead and explain to me why you haven't paid any child support in the past 7 months. You have to unmute yourself, sir.
Yes, Your Honor. I'm appearing under special appearance exclusively to address the challenge to jurisdiction. I request that no substantial matters proceed until jurisdiction clarification is fully resolved over my personal property. For the record, I request that all responses to the questions in my demand for clarification on jurisdiction be fully documented in court record. So a clarification of demand that was sent, that should be filed. That's what you're referring to. Demand for clarification of jurisdiction.
Okay. You have a child support order. Ms. Simmons has a child support order in DeKalb County. You are under an order to pay child support. In the state of Georgia, it is a crime to not support your children for 30 days. The law states that the case should be filed where the mother resides with the children. Ms. Simmons, I'm just going to unmute you. Ms. Simmons, where do you reside at this time?
DeKalb County.
DeKalb County, and where do the children reside?
Yeah, also DeKalb County and Stone Mountain.
And where are they attending school? In what jurisdiction?
DeKalb County, Stone Mountain, DeKalb County.
Okay, thank you. For criminal purposes, I do find I have jurisdiction over you, Mr. Simmons. You are the father of these 3 children. There's an existing child support order for you to pay child support. You're failing to pay the child support. You have not paid child support in 7 months. I'm still waiting, so give me one moment before I proceed. You don't want to explain to me why you're not working, what you're doing. You have 3 children with Miss Simmons, and you're not making any effort to comply with my order. The jurisdiction is determined that I absolutely have jurisdiction over you because your children are not being provided for by you. The last time we received was some unemployment in April and nothing since then. So there's jurisdiction over you. What else do you want to address, Mr. Simmons?
Your Honor, my demand includes several fundamental questions regarding the nature of the court's authority. I respectfully request the court provide clear answers to these questions before asserting jurisdiction over my personal property. Specifically, is the state of Georgia operating as a corporation or as
Sir, I'm not entertaining those questions.
Yes.
Those are sovereign citizens questions, and I'm not answering those questions. So I'm going to mute you for right now. I have jurisdiction over you. I have jurisdiction over your children. This is an appropriate proceeding. This is a government entity, and I have jurisdiction over our court in DeKalb County have jurisdictions over you. So this is the sovereign citizen kind of thing where people act like they're not, or they present that they're not members of the United States. And yeah, no, sorry, sir. You can present whatever you want in writing, but I've already determined I have jurisdiction. You've appeared in court before. You've never made an issue, so I'm not going to let you, try to say we don't have jurisdiction over you. You've appeared multiple times before our court. All right, so give me one moment.
We looked in the inbox as well to look on the file. We do not see anything on file as far as from Ms. Simmons. Not saying she didn't, but we don't see anything in the actual inbox or attached to her file.
Do you have it already scanned, Ms. Simmons?
Myself, no. They did also stamp it to say that it was received by magistrate court as well. So,
okay, well, you can just tell me what it was. What was it?
Yeah, Mr. Simmons, he submitted something apparently to Superior Court. I received a certified copy of a letter in the mail stating basically that he believed that he should not be liable to pay child support because he did not agree to pay child support. Essentially, he said that he was under duress in having to pay child support. That was
Okay.
the basis of his.
All right. So there are a number of like entities out that go and challenge jurisdiction and, you know, the things that he's trying to do, reading some script of narrative that the judge doesn't have jurisdiction. And sometimes they say they're not a legal person. And yeah, I'm finding that you are a legal person. You've already appeared before the court, so you can't bring any new argument before the court. I do find that you're intentionally abandoning your 3 minor children. So I am issuing the warrant for your arrest, sir. You can turn yourself into DeKalb County Jail. Ms. Simmons, unfortunately, this doesn't expedite. It's just going to go to court. They will arrest him when it's time. They'll take him into custody, and then your case is going to be transferred to state court. So once your case is transferred to state court, Mr. Simmons, if you are recording this proceeding, I am going to hold you in contempt and I can issue another warrant for your arrest. You are not to record this proceeding.
I'm not actually recording. My advice is to make sure that this is being represented accurately.
Are you recording this proceeding, Mr. Simmons?
I'm not recording this proceeding at all.
All right, thank you. Well, I was trying to give you an opportunity to explain why you haven't paid child support. You're determined, you tried to address jurisdiction. I find there's jurisdiction over you, your children. So with that being said, sir, a warrant's been issued for your arrest. You're not providing support since April. And you did good. You got off the case and then you decided to go this route. That's on you. So $2,000 regular bond. Usually I give unsecured judicial releases, but I'm not because it's your second time before court. You can turn yourself in if you choose. If not, then there'll be a warrant outstanding for your arrest. And when they pick you up,
okay. I'm making special appearance to actually address the jurisdiction. And so what I'm trying to do is clarify that first. I know you mentioned about jurisdiction, but I'm trying to answer the questions that are in the demand for clarification for jurisdiction. So those questions that was actually submitted, and I'm waiting for you to open.
Oh, that's not me. That's Superior Court. I'm not.
No. I walked it in personally to the magistrate court. I put it in there. The same document she's talking about. I put that.
Okay, sir. You can ask me the questions about jurisdiction. I've already told you I have jurisdiction because your wife and your ex-wife and your 3 children live in DeKalb County under Georgia law. I have jurisdiction over the case. What other question do you have? And because you're the father that birthed those 3 children, you're the one that I find is committing a criminal offense. So a warrant's been issued for your arrest. What question do you have about jurisdiction?
Is this jurisdiction being fully documented in a court of record?
Yes, it is.
Okay. And apart from that, when I mentioned about the request for the court to provide clear answers to the questions before a certain jurisdiction of my personal property, they're written in the clarification for demand that was filed.
I'm not taking any jurisdiction over your personal property, sir. I'm taking jurisdiction over you. And a state court will decide whether or not you're going to go before a judge or jury. So that concludes our hearing, sir. Ms. Simmons, you'll just go to the DeKalb County court and they will DeKalb County State Court, your case has been transferred. Mr. Simmons has not paid support. Seems like he's not going to pay support. So I would also recommend through child support that you file a motion for contempt because I'm sure he has the ability to take care of himself. And he sounds to me like he's challenging whether or not these children should be supported by him. So, sir, you could take that up in Superior Court, but for criminal purposes, I've already determined that we have jurisdiction. Okay, that concludes our hearing. Ms. Simmons, if you go to Odyssey, DeKalb County Odyssey, do not unmute yourself without my permission, sir. In Odyssey, you have to track your case. Okay, give it about probably beginning of the year. Go into DeKalb County Odyssey, keep putting his name in until you finally see something come up. And once it comes up, try to go to court if you can to advocate for the child support, because sometimes if mom isn't there, it just makes a difference when moms are active with the court and making sure that the support is provided. And I thought, if I don't know, did you have a special needs child one?
Yes, that's right. Naomi has special needs. Yeah.
Okay.
Promissory.
Okay. I'm so sorry you're going through this, but hopefully you will be able to continue to do the best that you can do with it. All right, that concludes our hearing. All right, Mr. Simmons, you could turn yourself into DeKalb County Jail. If not, there's a warrant outstanding, and when they do a sweep through any different counties, then you'll be arrested and taken into custody. You have a bond of $2,000, and that concludes our hearing. I'll give you one final word if you have a question, Mr. Simmons, but I'm not dealing with jurisdiction questions because I've already determined I have jurisdiction over you. Do you have anything else that you need to say before I conclude the hearing? You can
Yes,
unmute.
I'm here on special appearance.
Okay, thank you. We appreciate your special appearance. You're excused from court. We can go ahead and excuse Mr. Simmons and Ms. Simmons from court, and that concludes our hearing on that case.
I believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. that's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, with this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes them to collect more child support. The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And it's basically it's evidence they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
I'm not threatening you. Say one more word and that's 30 days. 30 days.